Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, it's not often here at Washington Gun Law that we get a chance to circle back, if you would, back in time to a piece of legislation which is as controversial today as it was when it was passed in 2018. What am I talking about? I'm talking about Initiative 1639. Why are we talking about Initiative 1639 in the year 2022? Well, that's because something happened this week in the Ninth Circuit that we, as lawful and responsible gun owners, need to be aware of. So, let's spend a few minutes today talking about, did the Ninth Circuit just strike down parts of Initiative 1639? Okay, so the case we're going to be talking about today is Jones v. Bonta, okay? And yes, I've had the opportunity to go through the whole thing, made copious little notes, and we're going to kind of geek out on this case a little bit. Now, if you guys don't like the really geeky law programs, this might not be one for you, but I'm going to come at it really fast and furious here. I'm going to try to hit you with a bunch of things and let you know what this means, because I think this has the potential to have a significant impact here in Washington State. Now, let's back up for a second and talk about what just happened. Well, what just happened is that the state of California, who is always at the cutting edge, if you would, of how can we take away our citizens' Second Amendment rights, had two pieces of legislation, and they're going to sound very familiar to you. The first piece of legislation is that anyone in that age of purgatory, that is age 18, 19, or 20, those 3 years of purgatory, they could not buy a long gun, a rifle, unless they had taken a hunter safety class, okay? They also were prohibited by statute from purchasing assault rifles, and the correct term in California law, in the California statute, was semi-automatic assault rifle. Now, I know right away some of you are going to start flipping out, and you're going to be the comments down below there. Quit calling that, quit calling that. I am using the language that's in the actual statute that we're discussing today. So, required to do a safety class to get a rifle, couldn't get an assault rifle at all until you were age 21. Both of those sound hauntingly familiar, don't they, to what's in 1639. What did the Ninth Circuit say? Well, the Ninth Circuit said, hey, listen, the requirement that these younger people go through a class before they can obtain this firearm, that's actually okay. And they used a certain analysis to come to that conclusion. We're going to talk about that. But this blanket ban on 18, 19, and 20-year-olds, where you're saying they cannot even purchase a semi-automatic assault rifle, well, that's unconstitutional. That violates their Second Amendment rights, and that is hereby struck down. Okay, so why is this important to us here in Washington? Well, a couple of reasons. First of all, Washington, as you all know, does lie inside the Ninth Circuit, so this has precedential value here in the state of Washington. Number two, let us not forget that if the world was flat, the Ninth Circuit is so far to the left that they would, in all likelihood, fall off. Okay, this is by far the most liberal of all the circuit courts anywhere in the United States. It has traditionally been the most liberal. They take great pride in being the most liberal of the circuit courts. And of course, that does not bode well when we are trying to challenge the constitutionality of gun control measures. Now, when I get to the end of this program, I still think that this is not hooray, hooray, this is an absolute victory. I still think there's a way that we're going to end up losing on this issue. But in the meantime, anytime that you have a gun control measure which has been struck down by the Ninth Circuit, yeah, there's something to this. Okay, so for those of you who've been lawful and responsible gun owners for a number of years now, you will remember Initiative 1639, passed by the voters of the state of Washington through the initiative process in November of 2018, enacted into law in July of 2019. Now, it did a litany of things, and how it didn't violate the single subject rule of the initiative process, I don't know, but apparently the $30 car tabs did, but I digress. But amongst the things that it did, it created what was called enhanced background checks, mandatory waiting periods, safe storage provisions, gun lock provisions, more burdens placed on the FFL, and then it did two other really important things that is germane to our discussion today. The first of all, it required that under 941.080 that we have to complete a 1639 safety class over 6 subjects before we would be deemed safe enough to purchase a semi-automatic rifle. The other thing it did, though, and this is super important, is it amended RCW 9.41.240, which lists the age in which you have to be in order to purchase certain types of firearms, depending on their platform. And in Washington State, 1639, back in 2019, when it was enacted into law, said, hey, if you're 18, 19, or 20, you can't purchase a semi-automatic rifle under any circumstance. Sound familiar? Okay, so why is this important? Well, it's very important because what the Ninth Circuit said is a law, similar to 941.240, is violative of the Second Amendment and therefore is unconstitutional and therefore was struck down. That has a significant potential impact to a class of individuals in this state aged 18, 19, or 20. The other important thing, and this is really important when we step back and we take a look at the big picture, and this is where we're going to get really geeky here for a minute, and I'm going to try to make it not boring. We know that the New York Pistol Rifle and Association v. Bruin, a case that we're waiting for a ruling any day now out of the United States Supreme Court, has the potential to have a huge impact, even a far greater impact than the last time that the Supreme Court weighed in on the Second Amendment, which was about 13, 14, 15 years ago in Heller v. District of Columbia. Now, again, not trying to geek out too far here, but Heller v. District of Columbia made it very clear that when we're talking about Second Amendment regulations, the analysis that we look at to determine is it good law or is it unconstitutional is a strict scrutiny analysis. And under a strict scrutiny analysis, according to Justice Scalia, if the law infringes upon the use of a firearm which is commonly in use at the current time, on its face, boom, it's unconstitutional. We don't get into any other further analysis. And if every federal circuit court applied the same analysis that Justice Scalia made very clear should be the test in each of these things, most of our magazine bans, AR bans, and some of the other goofy gun laws around the country would not stand constitutional muster. But what most of these other courts have done, and anytime you read dissenting opinions, as you would in here too, what they want to do is they want to apply an intermediate analysis. Now, intermediate analysis, when we're trying to assess the constitutionality of a restrictive gun law, means that we're going to actually do a balance test, okay? We're going to take a look at what the individual right is, and then we're going to take a look at the societal need that it requires this law, and we're going to weigh the two. And obviously, if the individual still reigns supreme, the law is unconstitutional. But if society's need outweighs the individual right, then the law is deemed constitutional. Well, this little goofy, this balancing test, if you would, allows people of a certain political agenda, of course, to put their thumb on the scale. And that is the big thing here, because if the proper scrutiny is applied to any gun regulation, and that is strict scrutiny, and Justice Scalia made it very clear in Heller, and candidly, all these circuit courts and many of the appellate courts around the country are just simply ignoring it, okay? But if that is the true analysis that we use for things that are affecting the types of firearms in common use at this current time, then none of these magazine bans, none of these AR bans, nothing could actually stand constitutional muster. And what the Ninth Circuit said is, hey, listen, when it comes to this regulation about requiring them to take a safety class, because that's not barring their access to a firearm, it's not barring their access to any particular type of firearm, it's just saying, hey, we want you to get some mandatory education before you can have it. We're not going to use a strict scrutiny analysis there. Instead, we are going to use an intermediate scrutiny analysis because we're not barring their absolute ability to get that firearm. So the Ninth Circuit made it very clear, and Justice Scalia would even agree with this in Heller, that when we're talking about those types of regulations, that is the type of analysis. We take a look at what's the right here. The right here is for the kids to be able to get the firearm without having to take the class. The societal need is education apparently would lead to more gun safety and therefore to fewer accidents and deaths and so. And we can debate that point, but that's the public policy arguments, okay? But when we get to a point where we're going to just flat out ban your access to a type of firearm because of an age, like you can't have an assault rifle, you can't have a magazine that has more than 10 rounds. The case law is very clear when you look at Heller. The case law is very clear when you look at this case that it is a strict scrutiny analysis that needs to be applied, okay? And what the biggest thing that can come out of New York Pistol and Rifle Association v. Bruin is yet again another announcement by the Supreme Court that says, listen, when we come to these restrictive gun measures, it is always going to be a strict scrutiny analysis, because if the courts properly applied that test, most, if not all of these crazy gun regulations would not stand constitutional muster. Now, I do want to give a special shout out to your Attorney General, Bob Ferguson, who, yes, weighed in as amicus on this, not only on behalf of the citizens of the state of Washington, but he also weighed in on behalf of Illinois, Connecticut, Delaware, District of Columbia, Hawaii, Maryland, Massachusetts, Michigan, Minnesota, New Jersey, New Mexico, New York, Oregon, Pennsylvania, Rhode Island, Vermont, Virginia, and of course, Washington. And for those of you who don't know what amicus brief is, that's basically a friend of the court. So here is our Attorney General weighing in favor of California's AR ban on age 18, 19, and 20-year-olds. I wonder why. Perhaps he's aware of what RCW 941-240 says and what Initiative 1639, an initiative that he sponsored, says. Okay, remember, now the case again is Jones v. Bonta. Bonta is the current name of the Attorney General in California, so you're going to see him on a lot of litigation coming up. But here, I mentioned earlier that, hey, let's not totally start popping the champagne corks yet, because here's what likely could happen. For those of us who followed the other case of Duncan v. Bonta, originally called Duncan v. Becerra, that is a case that's now all the way up to the United States Supreme Court, waiting to see if they'll accept review, that challenged California's magazine restriction, very similar to Washington State's, actually a little more restrictive than Washington State's. Now, for those of us that tracked this case, what we know is that at the trial court level in San Diego, the plaintiff, Mr. Duncan, won, and there was an injunction on California's magazine ban. That was, of course, then appealed by the state of California to where? That's right, the Ninth Circuit, and they assigned it a 3-judge panel. Now, there is as many as 11 justices on the Ninth Circuit, but it was assigned to a 3-judge panel. The same thing occurred here. Now, in this case, Jones lost at the trial level. He asked for an injunction. The court denied it. He appealed now to the Ninth Circuit to a 3-judge panel and has prevailed by a vote of 2-1. So there was one dissenting vote here. But here's what the state of California can do. Here's what the state of California likely will do, because the state of California doesn't like losing. What they're going to likely do is appeal this to a full panel of all 11 judges. Now, that panel does not have to accept review. Neither did they have to in Duncan v. Becerra, now called Duncan v. Bonta. But after Duncan won at the 3-judge panel level, oh yes, they impaneled all 11 justices, and we all knew at that point the fix was in. You could just take a look at the political breakdown of the court, and you knew exactly how the vote was going to break down, and shockingly, it broke down exactly along that party line. So, what's likely to occur here? You know the state of California is going to appeal this. You know it's likely going to be accepted by the 11-judge panel, and at that point, the math ain't going to be in their favor. And yet, this could be another case headed to the United States Supreme Court. And this particular Supreme Court now has shown a little bit of orneriness that we haven't seen in a while. We already are waiting New York Pistol and Rifle Association v. Bruin. We have Duncan v. Bonta that's up there. This case could end up there as well. And there are several other important cases, including some other challenges to outright AR bans. There's one, I believe, Bianchi v. Frosch, which is out of Maryland. And then there's another case with the last name of Bonta out of California. So there are 2 cases also challenging outright AR bans. I'm sure our Attorney General will write an amicus brief on that as well. But this has the potential to be some significant years of major Second Amendment litigation. Listen, we'll be doing more videos on this because I do anticipate that someone will be filing for an injunction in Thurston County any day now to for a cease and desist or an injunction to stop the enforcement of RCW 941-240, which could create a situation in which those 18, 19, and 20 years old who are otherwise lawfully allowed to possess a firearm and who have completed their 1639 safety class, because I think this case clearly shows that that is permissible, you actually might be in a position where you can legally purchase a semi-automatic rifle. Listen, you may have more questions about this case or anything else related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.